You may be seated. Ms. Londy.
Good morning, Your Honor. Ashley Londy for the people. Your Honor, at this time, would waive any conflict with this honorable court and the Office of Public Defender. Do not believe that any conflict exists. Make waiver for the avoidance of all doubt.
Good morning, Your Honor. Intern Malaika Fatima requesting to practice under MCR 8.120 under the supervision of the Deputy Chief Public Defender, Lauren Brown.
Permission to practice is granted.
Thank you, Your Honor. We do not believe there is any conflict between this honorable court and our office, and if any conflict is to arise, we waive that conflict so that this honorable court can hear these matters.
And the court, for its part, also does not believe that there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Ryan Pfeiffer.
Good morning, Your Honor. Jacob County, on behalf of the people.
Malaika Fatima appearing on behalf of Ryan Pfeiffer.
Where is he? Is he? I'm not picking him up.
He is on.
Mr. Pfeiffer, can you state your name, please? Oh, there, I got it.
Yes, sir. Ryan Pieper.
Sure, okay. Thank you. All right, what are we doing today?
So has the court received the evaluation from the forensics?
I have, it is dated June 18th, that one.
Yeah, so we sent an order finding him competent. We have nothing further to present. We would like to set it for probable cause conflict.
Anything from the people? All right. Court, based upon the people that report, would find that the defendant is competent to stand trial. Specifically that the defendant can understand the nature and objects of the proceedings against him and can understand and can rationally his defense. Therefore, the defendant is deemed competent. Like to set for a probable cause conference.
Yes.
Yes.
Yes, Your Honor.
All right. You want 2 weeks out? Will that be enough time for you?
Yes, 2 weeks should be fine.
Probable cause conference will be set July 10th, 2025, 9 a.m.
Thank you, Your Honor.
Thank
Thank
you.
you.
Bond will continue.
Thank you.
Court does call the case People versus Brian Brown.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Oh, good morning. We do not have Mr. Perkins. Counsel, have you heard from Mr. Perkins at all or his office?
No, Your Honor.
Mr. Brown is not here, is that right?
Mr. Brown is in Dade County.
Pardon? Oh, there he is. Mr. Brown, can you state your name?
Ryan Brown.
All right. Your attorney has not signed on. Was he coming by Zoom or in person? Pardon?
I do.
All right. Contact his office. I'm going to pass this matter briefly, sir, okay? Try to get your
Yes, sir.
attorney here. Court does call the case of the People versus Christopher Nunley.
Student Attorney Kara Rosengren requesting permission to practice under Michigan Court Rule 8.120 on behalf of Attorney Hannah Apple under the supervision of First Assistant PD Michael Gotti.
Permission to practice is granted. Sir, can you state your name, please?
Christopher Nunley.
All right, what are we doing on this?
Thank you, Your Honor. We're requesting to adjourn as Attorney Apple has a meeting scheduled in person in Jackson on 7/25 at 2:30 p.m. with Mr. Nunley. So we're going.
7/25.
Yes, July 25th.
She couldn't get one before. That's a month out.
Yes, Your Honor. From my understanding, they only allow in-person visits in Jackson on Fridays, Saturdays, Sundays, and Mondays, and only in the afternoon.
A lot of those between now and then.
That was the first available that she could get, Your Honor.
July 31st, 2025, 9 a.m.
Okay, thank you, Your Honor.
Court does call the case of the people versus Anthony Lafredo.
Assistant Public Defender Natalie Pate with it on behalf of Mr. Lafredo, who is present via Zoom from the Jackson County Jail. Sir, can you please unmute and state your name for the court?
Anthony Lafredo.
Thank you, sir.
Thank you, Your Honor. I have a video visit scheduled with Mr. Lafredo tomorrow morning at 10 a.m. There is
So it's not a month out?
No, Your Honor.
Oh, okay, go ahead.
I finally got approved, but it's scheduled for tomorrow morning. And there is an offer in this matter that I wish to convey to my client. So I would ask for a brief adjournment.
Without objection, July 10th, 2025, 9 a.m. Bond continued. All right. Thank you, sir.
Your Honor.
Thank you, sir. We'll talk tomorrow.
All right, thank you.
Court calls the case, people versus Anitra Comer.
Sarah Rosengren, under the supervision of First Assistant PD Michael Gotti, on behalf of Ms. Coomer.
Comer, can you state your name, please?
Anitra Coomer.
Thank you.
Your Honor, we're asking to adjourn as we have an application pending for a visit to the Women's Correctional Facility.
Okay, how soon has it been cleared? I realize there's a problem with these visits, but
Yeah, I'm sorry. I'm unaware, Your Honor, if it's clear or not. I just know that the application is pending. It has been put in.
July 17th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the cases of the people versus Terrell Green.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Green. Mr. Green, please state your name for the record.
Terrell Green.
Thank you.
We're asking you to set all three cases for preliminary examination, please.
Discovery is complete.
For my understanding, yes, Your Honor.
People have their witnesses available July 8th. Or where is he?
He's in MDC, and with the holiday, I'm a little concerned with our ability to get him. We get the 15th.
Any objection?
No, Your Honor. He's in county, but he is incarcerated, so either way.
Is he here? He's here?
No, he's
No.
in Livingston.
Oh, Livingston.
I'm concerned about being able to get a quick turnaround.
All right. Understood. Preliminary examination in person will be set July 15th, 2025, 9 a.m. before Judge Moore. Bond will continue.
Thank you.
Court does call the case of the people versus Robert Moyle.
Alexander.
Brian Bowling on behalf of Mr. Moyle, you're just state your name on the record, please.
Robert Moyle.
Your Honor, we're here to ask for a examination on this matter today. To my understanding, all discovery is complete.
People have their witnesses available.
We'll do our best, Your Honor.
Preliminary examination in person will be set July 8th, 2025, 9 a.m. before Judge Balvo. As to Bond.
Your Honor, it's come to my attention that this defendant has made 6 complete calls to the victim in this case, as well as 68 attempts to call. At this time, I'll be asking that this phone please be revoked.
Any response?
Well, Your Honor, I'll just state that that's the first I'm hearing of this. Obviously, I don't know what the substance of those conversations were or that they were actually even placed at this point in time. I'd ask the court to deny that motion.
Defendant's bond will continue in its monetary fashion. However, pending a hearing, if the defendant requests, defendant's phone privileges are hereby revoked.
Thanks, Judge.
Court, you guys got to keep moving. Court calls the case of the People versus Robert, is it Ciotti? Ciotti.
Good morning, Your Honor. Sam Bernstein for Mr. Ciotti. I've been unsuccessful in being able to reach him, so just me today.
Bench warrant will issue for defendant's failure to appear. Bond will be set at $10,000. Cash surety, that warrant will issue immediately. Court calls the case People versus Antonio Williams.
People.
Cindy Cropper.
In the back.
Pardon?
There was a bunch of them ganged up.
All right. Your name, sir?
Oh, Antonio Williams.
All right. Mr. Williams, you're appearing here at a probable cause conference without counsel. I will advise you that you are charged with the offense of assault with intent to do great bodily harm less than murder, felony punishable by up to 10 years incarceration and a $5,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
All right. You understand also, as I've indicated, that you're appearing here without counsel. Let me first ask you, is it your desire to proceed without counsel, or do you
No.
wish to have an attorney?
I wish to have an attorney.
All right. This is a public defender case.
First Assistant Public Defender Michael Gaddy on behalf of Mr. Williams, Your Honor.
All right.
I'd ask the court to adjourn the probable cause conference to allow us to obtain discovery, get officially appointed by the appointing authority and
Well, I don't think
matter with
it
Mr.
really does, that doesn't need to be done, but.
Oh, good. Okay. I don't know how.
It's already done.
Oh, great. Okay. Your Honor, I would then ask for an adjournment of the probable cause conference so we can obtain discovery and review it with Mr. Williams.
July 10th, 2025, 9 a.m. Bond continue.
If I could ask the court what the bond is current.
Bond in this matter is currently set at 100,000 cash surety.
Thank you, Judge. We'll come visit.
Court does call the case People versus Andy Rosales.
Ashley Lonnie for the People.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Rosales. Please state your name.
Andy Rosales.
Your Honor, discovery is complete. We're asking the court to please set this for exam.
People have their witnesses available the 8th.
We'll try, Your Honor.
Preliminary examination will be set in person, July 8th, 2025, 9 a.m. That is before Judge Freshour.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue. Thank you.
Bye later, man. Thank you.
Court calls the case, People versus David Merrickman.
Morning, Honor. Assistant Public Defender Costin Bovese on behalf of David Merrickman, who is approaching the podium to my right. Mr. Merrickman, can you state your full name for the record, please?
David Merrickman?
All right. What are we doing on this today?
Yes. Yes, Your Honor. As far as the probable cause conferences, we would ask that these be adjourned to continue negotiations for a global plea. I understand that my client also has a bond violation. He is prepared to admit to that bond violation today.
So he does not wish to have a hearing on that violation?
No, Your Honor. He wishes to admit full responsibility.
And then having admitted to the violation, court will accept that admission. I will adjourn this matter out to July 10th, 2025. 9 a.m. Given the nature of the bond violation and his bond, at this time, his bond is no bond.
So his bond is no bond, Your Honor?
Yes, I think it is at this point. I think I revoked.
You haven't actually addressed that.
I have not addressed the violation.
That's correct.
All right. Anything from the people regarding the?
Your Honor, I would ask that bond be revoked on this matter. This is a case where the defendant was on probation. The victim on his probation matter is the same victim on the malicious destruction case before this court. Given that he was out on tether and still cannot be trusted to follow with that order, I think revoking bond is appropriate at this time.
Any response?
Your Honor, my client has been in for 10 days. I think he's had a lot of time to think about his decision. He did turn himself in on this bond violation. As I understand it, he had a moment of not good decision making. He thought about it, realized it's not what he wanted. He doesn't want to be on the run, Your Honor. He wants to follow the court's orders. So he turned himself in. He's hoping to get a new tether and get back out and hopefully get back to his job. He has a job in landscaping. He's hoping to keep that job, Your Honor. He is willing to go back out on tether and do whatever the court needs him to do if that's what the court deems appropriate.
The problem is that there was at least a tamper alert and other things regarding the tether. So I don't know that the tether does anything for us at this point, given the defendant's conduct. So for those reasons, defendant's bond will be revoked pending further order of the court.
Understood, Your Honor. Thank you.
Court calls the case People versus James Williams.
Good morning, Your Honor. Christina Costantino appearing on behalf of Mr. Williams. Mr. Williams, can you please state your name for the court?
Yes, ma'am. James Williams.
What are you doing?
Your Honor, this is the date and time set for APCC. I was just recently appointed to Mr. Williams' case, and I do believe there is some outstanding discovery. So I would be asking for an adjournment. We will also be doing some mitigation for Mr. Williams. So I would be asking for about 3 weeks to ensure that's completed by the next PCC date.
Any objection for the people?
No, Your Honor.
Probable cause conference, July 17th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. The court does call the cases of the People versus Shavante Vincent. Or Siobhan Vincent.
Good morning, Your Honor. Amy Rise on behalf of the people.
What is yours? Court trustees to Assistant Public Defender on behalf of Ms. Benson.
One.
Hello, how you doing?
Your name, ma'am?
My name is Siobhan Benson, known as Truth.
Thank you, Judge. I believe you were here a couple weeks ago and Ms. Vincent was found to be competent.
Yes.
I think at this time we are prepared to set this matter for preliminary examination. I know Ms. Reiser was looking into the availability of her witnesses and officers. I don't know if the court has some dates we can look into.
Yes, all right. And all discovery is complete on your.
That's my understanding, Judge, yes.
Gotta let my shirt be seen. Stand tall for my daughter.
So, when's mine?
All discovery is complete already. Have some correspondence.
Yes.
With Mr. Feaster this week at the hearing on March 21st, 2025. Detective Roberts advised all counsel that they could bring a terabyte hard drive for the larger documents and downloads that couldn't be emailed or sent over. So I believe that is going to be done by Mr. Feaster this week.
Yes, thank you, Ms. Reiser. My client was concerned about getting the information out of her.
Oh, I'm sorry. Yeah, I'm good. I
apologize. My client was concerned about getting some information out of her cellular phones. Ms. Reiser indicates that they should have that, and I can get a hard drive and have my investigator go over and get a copy of that tomorrow. From all the evidence in that phone, my client believes there might be some
exculpatory.
Okay, so if they get that to you, I won't be granting an adjournment if for whatever reason it doesn't come through if I'm setting it for exam.
Well, if it's, do you want?
It's done, Your Honor. They just have to get the hard drive.
Okay.
To get the forensic report download.
Yeah, if Ms. Reiser says it's done, I believe it's done.
Okay.
So if it's done, we'll get it tomorrow.
Then you can, because the other part of the case was set before me, I'd be setting this part.
That's fine, Judge. Ms. Reiser says that your phones have been dumped and that we can get a copy of everything.
Dumped like how? Like they took the evidence off of it?
No, it's
I got
preserved for you.
evidence.
Yeah,
Okay.
and we can go pick it up tomorrow.
Yeah, these people were pedophiles. They were demons.
I got it.
They sexually assaulted my daughter and abused her. Period.
I got it.
Just hold on. All right.
I'm gonna expose them. They're gonna be exposed.
Vincent,
I'm sorry.
please.
Sorry, Judge.
I'll set this for July 22nd. That'll give you time to get that, go through that with your attorney, and it'll properly be set before me.
Sorry, Judge, if I could just confirm that I am here on 22nd.
On 9 a.m.
Okay, would you?
I'm sorry, what is it? No. That's a combination date, so it's 12. Okay. No, let's just do it. I'll set, well, why don't we do this? I'll set it at 1 p.m. on the 21st. On the 22nd, excuse me.
So
July 22nd, 1 p.m. before me.
Thank you. The only witness that is unavailable is one of the.
Vincent, you got it.
He's so close, so I,
No, okay, I got you. But just face this way. Go ahead.
The only witness that is unavailable is one of the sheriff's department witnesses on the sheriff's department case. And I don't know that we'll even get to that on the
21st.
I presume we'll start with the homicide. I'll have the sheriff's department witnesses for the CCW, RNC, RNO on standby.
All right, very good. Okay, so I'll set it.
Are we setting that on the 22nd as well? Do you want to?
I'm going to set all of them on the 22nd. Okay. And then we'll sort them out from there. July 22nd, 2025, 1 p.m. That's before me. And we'll continue.
Thank you very much, Judge.
All right, thank you.
Yeah, hang in there.
All right, I got it.
All right.
Thank you.
Court does.
Thank you, Judge.
No, Miss Vincent, no. Court calls the case, People versus Clifford Gordon.
Edward Drukas for Clifford Gordon, who is approaching, Your Honor.
Good morning, sir. What's your name?
Clifford Gordon.
All right, what are we doing?
Your Honor, I'm asking just for a 2-week adjournment. There are some outside counsel that I'm using for mitigation, and if I could have 2 weeks.
Without objection, July 10th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, sir.
Thank you.
Court calls the case, People versus Myron Barnes.
On behalf of people.
Morning, Your Honor. Sam Bernstein for Ms. Foster Tucker for Mr. Barnes. Mr. Barnes, could you please state your name for the court?
Myron Barnes. Thank you.
Your Honor, in this case, we are asking for an adjournment resolution, and we will submit an order to the court for release to drug treatment as well.
Probable cause conference will be adjourned July 10th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Julius Holston.
Edward Drucas for Julius Holston. Who is
Your name, sir?
Julius Host.
Thank you. All right, what are we doing?
Your Honor, I'm asking for at least a week to facilitate the new form for a misdemeanor plea in this case.
When's my next one? 20, I'm sorry. No, PCC.
Oh, I'm sorry.
I've got the 3rd though.
Yes.
All right. If you've worked out a resolution, it's just a matter of putting it into its form. Is that what I'm to understand?
Yes,
sir. Probable cause conference, July 3rd, 2025, 9 a.m. One count. Bond will continue. Thank you, sir.
Thank you.
Court calls the case of the People versus Daniel Bauer.
Good morning, Your Honor. Lori Yagi, Assistant Public Defender, with and on behalf of Mr. Bowers. Who's approaching Mr. Bowers? Can you say your name for the court?
Daniel Bowers.
All right, what are we doing?
Your Honor.
Hold on.
Sorry.
I need the other side.
Yeah.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Thank you. What are we doing?
Your Honor, I met with Mr. Bowers and I believe he's prepared. He is signing right now the examination waiver. So I believe he's prepared to waive his preliminary examination. Is that right, Mr. Bowers?
Yes, I am. I waive, Your Honor.
All right. Mr. Bowers, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, I understand, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further.
Yes, I know. I'm aware of, Your Honor.
That's what I've done. Counsel, people also waive their right.
Yes, Your Honor.
All right, preliminary examination having been waived, defendant is bound over to circuit court on a single count. Ms. Yagi.
We would waive formal reading and stand mute, Your Honor.
Defendant every way, formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for. What do we not have? Oh, please.
Using their bond. They didn't respond. They don't.
May I object? It's Conlon.
Okay.
Okay.
So if you want to talk over next, it's okay. And I've been in touch with you.
Hold on a second. We're not gonna do that. What date is this? Mr. Feaster, what days are Judge Conlon on?
It's Judge Con. Oh, this is, I'm.
Pardon?
You know,
Give me the Wednesday, 2 weeks out.
He's told me when I got arrested on the Navy base.
Pretrial in this matter will be set for July 9th, 2025, 9 a.m. Bond will continue. I suggest that council check that date since I don't have the ones in.
Yes, Your Honor, thank you.
Get that down.
Thank you.
Court does call the case People versus Gregory Bell.
supervision of.
Don't be so shy about it. Just say it like you mean it. Yeah.
Hello for the people requesting permission to practice under Michigan Court Rule 8.112 under the supervision of the state. Assistant.
Ms. Lowe. Is O a number or a letter? Start over.
Permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of the Assistant Prosecuting Attorney General.
Permission to practice is granted.
Your defense is gonna have to object to this one. No objection, Your Honor, of course, no, especially for a fellow Wayne Stater. Your Honor, today's the date and time set for a probable cause conference. I was very recently appointed to this matter, so we are asking for a brief adjournment, whatever the court's next date is.
Without objection, probable cause conference, July 10th, 2025, 9 a.m. Bond continued. Thank you.
Thank you. 9 a.m. Okay. All the way.
Court calls the case People versus Norman Johnson.
Alexander, on behalf of the people, Your Honor.
Sam Bernstein for Mr. Johnson.
Yeah.
You say your name.
Norman Johnson. Thank you, sir.
Your Honor, we're asking the court to please set this for preliminary exam. Discovery is complete.
You will have the witnesses available the 8th.
We'll do our best, Your Honor.
Preliminary examination in person, July 8th, 2025, 9 a.m. That's before Judge Valvo. Bond is continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case People versus Todd Ammerman.
Your Honor, Laura Yagi, Assistant Public Defender. Mr. Ammerman has been in touch with my office repeatedly. He's
Right
here.
here.
There you go. Good morning, Mr. Ammerman. Thank you for calling our office. Please say your name for the record.
Todd Ammerman.
Your Honor, I am asking for,
You are way too happy.
I'm very happy to see you
Yeah.
this morning.
Yeah, I'm happy to be here, really. Be honest with you.
Your Honor, I do anticipate, I was conveyed a plea offer in this case, but I need some time to talk to Mr. Ammerman. This is my first time talking with him, so that's why I'm so excited,
Yeah.
but
We all got that. All right.
I would ask for a brief adjournment
I'll
to
need a
talk.
green sheet,
Thank you,
but
Your
I'll
Honor.
adjourn it to July 10th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case People versus Christopher Atkins. Have we heard any? Christopher Atkins?
He is in now, Mr. Bowles.
Brian Bowling on behalf of Mr. Atkins, Your Honor.
Right, where is it?
Should be at the bottom of your screen. This camera.
Right, but his camera's off. Christopher Atkins? We're not getting a response. I'll pass the matter briefly as soon as we can do that. Have we heard from Mr. Perkins at all?
Thank you.
Yes, he's in another hearing for about 30 minutes.
For about 30 minutes?
Yeah.
Does the Attorney General have anything else?
Yes, she does. She has one more case.
All right, well, after that one, I'm calling that one and it's just gonna be put over because I'm not gonna wait for him. I'm not gonna have her wait. Court calls the case, People versus Anita Barnes.
Like a Fatima appearing on behalf of the bar.
Anita Barnes.
Thank you.
Thank you. Your Honor, we are requesting for a 2-week adjournment to review the media with the client.
Have a green sheet.
Sorry? Yes, I have a green sheet.
Probable cause conference will be adjourned July 10th, 2025, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Court calls case of the people versus Jonathan Miles.
Good morning, Your Honor. Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Your Honor, Alexis Plumai on behalf of Mr. Miles. Mr. Miles, could you say your full name?
Jonathan Dion Miles. Morning.
And Your Honor, today's the date and time for a probable cause conference. I am requesting a brief adjournment so that my client can get some bond money together to start working towards that standard offer. Your Honor, I have discuss the standard process with my client. He would like me to address bond if you would allow it briefly.
Probable cause conference will be adjourned July 10th, 2025, 9 a.m. Go ahead briefly.
Okay.
It's set at the 25%.
I understand
so you
that.
got to give me some reasons, otherwise it's going to stay right there.
Your Honor, so first and foremost, Mr. Miles is just unable to afford the bond as is. He could maybe post $500 tops, and that is with reaching out to family and friends. He just got a new job as a security guard, and he also has another job working for his family's shipping company. He's at risk of losing the job as a security guard right now. If he was released, he would be able to pay $100 to $150 a week towards his arrears. And he also has full custody of his 13-year-old, one of his children, who's waiting for him at home.
I don't need a response from the people. Motion for bond reduction is denied. It's set at the statutory threshold. So bond in this matter will continue. Thank you.
Thank you.
Understood.
Give me the green file now. Court recalls the case of the people versus Brian Brown.
Assistant Attorney General Clarissa Williams on behalf of the people.
What's our writ on Bay County? 2 weeks, it's still a writ. Okay. Mr. Brown, can you state your name?
Brian Brown.
All right, Mr. Brown, I don't know. It says he's in another hearing someplace, but I'm not going to detain the Attorney General. What I'm going to do is I'm going to adjourn your case out 2 weeks, all right? And we'll let Mr. Perkins know. All right?
Okay, thank you.
All right, then probable cause conference will be adjourned July 10th, 2025, 9 a.m. Bond continued. All right, thank you. Thank you. Court calls the case people versus Roderick Bates.
Jennifer Douglas for the people.
Morning, Your Honor, Mike Gaddy, Assistant Public Defender on behalf of Bates. Okay.
State your name.
Roderick Bates. There's still more discovery coming, question and adjournment.
Yes, Your Honor, it's like there's 2 police agencies and we need the video from the second one.
Probable cause conference July 10th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Court calls the case versus Lowry, Kevin Shivari Lowry.
Good morning. Charlotte Steffen on behalf of Mr. Lowry.
Your name?
Kevin Williams, Shinavar Lowry Jr.
Thank you. All right, what are we doing today?
Your Honor, we'd like to set up for preliminary examination.
All right, is all discovery complete?
I believe so.
All right. Would the people have their witnesses available the 8th?
We'll do our best, Your Honor.
Preliminary examination in this matter will be in person, July 8th, 2025, 9 a.m. That is before Judge Freshour.
Thank you, Your Honor.
Bond continued. Thank you, Mr.
Thank you.
Court calls the case of the people versus Nathan Bell.
Good morning, Your Honor. Permission to practice 20 under the supervision of Assistant Prosecuting Attorney Ashley Monty.
Watch this. Is that 8.120? Okay, never mind. Permission to practice is granted.
Malika Fatima appearing on behalf of Nathan Bell. For the record.
Nathan Bell.
Thank you, sir. All right, what are we doing?
So we are requesting for a 2-week adjournment for pending negotiations with the prosecutor. We are waiting for some hospital record confirmation.
Any objection from the people? Probable cause conference, July 10th, 2025, 9 a.m. Bond will continue. And the next hearing, I'm sure your client will know that I expect him to wear all of his pants. All right, thank you.
Thank you, Your Honor.
Court calls the case, people versus Molly Fox.
Jacob Kennedy,
Your name, ma'am?
Oh,
Thank you. All right, what are we doing?
well, Your Honor, I am going to ask for another short adjournment, and I have made up paperwork, and also ask you to grant bond again. The reason I'm asking for the adjournment and the reason I'm asking for bond are somewhat connected, and that is that she hasn't yet been interviewed for whether she would be eligible for the recovery court. Mr. Kennedy was kind enough to recommend or suggest that resolution to me. And yet, as I read the eligibility requirements, and as I talked to Annette Johnson this week, she would not normally be considered a candidate because this is an assaultive crime with which she's charged. But the circumstances of this case suggest that the incident that she's charged with had, had alcohol was a very significant contributing factor, and that she has a need for some kind of treatment. In fact, she had been doing.
Dennis, we addressed bond the last time that we were here.
That's true. She's been in a month
now.
now.
I denied the change in her bond. I don't know that anything has changed between that time and now.
Well, the only thing that may have changed, I don't recall what the assistant prosecuting attorney said last time. I don't really remember what she said. She was a sort of a fill-in, not the person who really is handling her case. Mr. Kennedy apparently has told me that he would be, if you were satisfied, he would be satisfied if she had maybe twice a week drops, because
if you guys want to submit a stipulated order, I will look at it and I will consider it. I don't know that there's anything that you're going to tell me that will lead me to change my mind from the last time I addressed it.
The other factor, Your Honor, is as I know you know, the recovery court is very labor intensive, you might say. It's extremely difficult to do, and in my opinion, I represented her in other matters. She will not be successful in the recorder's court unless she has full support of her family. But while she's in prison, in jail, it's difficult for her to talk to her family in this kind of a way.
Dennis, you made that exact same argument to me the last time.
Well, it's still true.
Okay, and my answer is still the same.
Okay.
Probable cause conference will be adjourned July 10th, 2025, 9 a.m. Bond continued. Motion for bond reduction is denied.
Thank you, Your Honor. Your Honor, would the court like a copy of the certificate of completion for the substance abuse that she has completed in jail?
Pardon?
Would the court like for your file a copy of the certificate of completion for the substance abuse treatment that she's had in the last?
You can send that to my staff. We'll get that to the file.
Okay, thank you, Your Honor.
Court calls case People versus Dominic Billing.
Andrew Childers, attorney on behalf of the people. Yeah.
Your Honor, Alexis Pluma, here, just right?
Dancing or what?
Appearing with and on behalf of Mr. Billing. Mr. Billing, could you just state your name?
Dominic Billing.
Your Honor, I am just requesting a brief adjournment. It's Mr. Billing's first probable cause conference. Like, we'd just like to discuss the case a little more before he decides what he wants to do.
Without objection, July 10th, 2025, 9 a.m. Bond continued.
Your Honor, would it be possible to go out one more week? That's my client's birthday.
Well, we'll all sing.
Please, could we go out one more week?
For a birthday?
Yeah. I mean, as much as I enjoyed being here on my birthday.
Wow. I didn't tell you to take that job. Did you hear that? I don't know. She used to be so nice. So what's this year, like birthday campaign? Anybody's birthday? We're not.
Yeah.
Okay. You know, you're lucky I like you. July 17th.
Thank you, Your Honor.
Court does call the case People versus Daryl Frederick. Maybe
I'm Laura Yagi, Assistant Public Defender with and on behalf of Mr. Frederick in 4 of the matters.
And Edward Drukas on behalf of Mr. Frederick in 5526 and 327.
Your name?
Daryl Frederick.
Thank you. What are we doing?
Your Honor, in the 4 public defender cases, I do believe discovery is complete. We are respectfully requesting that they be set for exam. I think Mr. Drukas is doing something different in his case, and I do have a physical waiver if he is.
What are you doing on your cases?
We were going to set ours for exam.
Oh, never
So
mind.
all of them are going
Sorry.
to be set for.
Okay, perfect.
All right, that's fine. Discovery is complete in your cases, Mr. Drukas?
Yes, Your Honor.
People have their witnesses available on the 8th. Preliminary examination in person, July 8th, 2025, 9 a.m. All of these are before Judge Valvo.
Your mom is here.
Bond will continue.
Okay. Thank you.
Thank you. Court does call the case People versus Daniel Bowe.
You're Raymond Cook for the people.
Talking about hearing on behalf of Daniel Bowe.
Really?
State your name for the record.
Daniel Bowe.
Thank you, Your Honor. At this time, we are requesting a 2-week adjournment.
Literally just came from the hospital.
We are requesting a 2-week adjournment to verify receiving the media and discovery. I believe it was sent over to our office yesterday.
July 10th, 2025, 9 a.m. Continue. And you'll talk to him about his attire.
Yeah, no, I just left the hospital this morning with my son. So
Oh.
that's the only reason.
Understood. All right.
Thank you, Your Honor.
Thank you. Look at those 1980s parachute pants. Just have them here. Anyway. Court calls case People versus Shania Williams.
And is it on behalf of the people, Your Honor?
Morning, Your Honor. Sam Bernstein with and on behalf of Ms. Williams. Ms. Williams, could you please state your name for the court?
Shania Williams.
Your Honor, we're asking for an exam date. Discovery is complete.
People have their witnesses available on the 8th. Preliminary examination in person, July 8th, 2025, 9 a.m. That is before Judge Freshour. Esteban.
Your Honor, it's come to my attention that the defendant is, while not calling the victim on this case, in her jail calls, I've heard a few concerning things. One of those being that talking to a friend saying that if the dad wants, who's the victim in this case? If her dad wants money, they'll bring the money not to come to court. She also asked a friend to stop her dad and his wife at the door of the courthouse before they can get into the courtroom today. So the case will be dismissed. I have concerns that she's contacting people to try and interfere with the witness participating in this case. So I would ask at this time that her phone privilege be revoked.
Respond.
I'm sure Ms. Zenda will send me the phone calls. I'll listen to them and I'll notice it up for motion if appropriate, Your Honor.
All right. Defendant's phone privileges pending any hearing requested by the defendant are hereby revoked.
I'll see how the action is.
Her bond will continue. Court calls case of the People versus Zaria Brain.
And then on behalf of the people, Your Honor.
And Assistant Public Defender Jay Ballinger on behalf of Ms. Brand. Ms. Brand, can you please state your name for the record?
Zaria Brand.
Okay, messed it up, I'm sorry.
And Your Honor, we're just asking for a few weeks of an adjournment. I'm seeking to do some mitigation, submit that to the prosecution for their.
You have a green sheet.
I do, Your Honor. I apologize. I have that right here.
July 17, 2025, 9 a.m. Bond continue.
Thank you.
Call him Monday, okay? All right, take care. Thank you.
Court calls the cases of the People versus Taruska Dennis.
Jacob Kennedy for the people, Your Honor.
Talking about appearing with and on behalf of Zachariah Taruska Dennis.
And good morning, Your Honor. Christina Constantino, appearing on behalf of Mr. Haruska Dennis. And I am appearing on the case number, the other case number.
So you don't come down to see us anymore?
Judge, I do. Trust me.
No, I'm not going to say anything.
I'd
No,
rather-
I wasn't
I'd
going to say
rather
anything.
be
I'm just
there
gonna leave
than-
it. It's like been 3 weeks.
I
Fine.
know.
I don't care.
I know. I'd much rather be there than where I've been. Trust me.
Okay. What are we doing? Thank you.
Your Honor, I believe we received the AIM report yesterday to our office, so we are requesting for a 2-week adjournment to review that.
How long?
2 weeks.
Any objection?
No.
And Judge, I would be
And that's,
requesting the same on my case.
Okay. Probable cause conference will be adjourned July 10th, 2025, 9 a.m. Bond continued. I'll need a green sheet, counsel.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Judge.
Court does call the case of the People versus Cordell Brown.
Your Honor, Alexis Plumite appearing on behalf of Mr. Brown. Your Honor, I haven't been able, I don't think he's here.
It's his birthday or something?
It could be his birthday or something. I haven't been able to reach him. I was able to confirm that he was released from the hospital, but looks like his phone is disconnected, so.
Bench warrant will issue for defendant's failure to appear. Bond 10,000. Cash surety. That warrant will issue immediately.
Thank you.
Court calls the case People versus Quincy Jones.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Jones, who's approaching, Your Honor.
And good morning, Your Honor. Sydney Rushing, appearing on behalf of Mr. Jones in case ending in 0697.
And my case is 21F105474FY.
All right, what are we doing?
Your Honor, I believe we have reached a resolution in these matters. We have the plea forms here. We did not submit them yesterday. We'd ask the court to make an exception or to adjourn this matter 1 week because we have all the documentation here.
Is that going to be on both cases?
Yes.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bound continue.
I have.
Thank you so much, John.
A green sheet in that eventuality. If I could be heard on bond, Judge.
Go ahead.
Thank you. Mr. Jones is, well, obviously he's here. He was taken into custody last time for failing to go to community corrections. He reports that he did get released.
Failing to go. There were some other issues, but go ahead.
He reports that he was released afterwards. He would avail himself of community corrections if released in this on this occasion. Also, he would be. I haven't been in contact with his worker over at Avalon, and they are willing to provide him with transportation if need be.
So how do we stop him from using?
Your Honor,
I know, hard question. Yeah.
He could be testing. He could do the CC, the community patients outpatient program while he is waiting this matter. He does live locally in Ann Arbor through the Avalon program.
I don't need a response. He was significantly intoxicated. Unless I see a full plan in place, I'm not doing anything along those lines.
Thank you, Your Honor.
Bond reductions tonight.
Thank you so much, Your Honor. Have a great day to you and your wonderful staff.
You too. Court calls case People versus Amanda Bryant.
Stephanie Cannon on behalf of Ms. Bryant, Your Honor.
Oh, I didn't know you had any cases.
My apologies, Your Honor. What'd you say?
No.
Oh. My pen.
Do you have a client?
Oh, thank goodness. Your Honor, I'm not sure who that young lady is on the screen. However, I have not communicated with my client. There's no name. It just says name ? So I'm not sure who that is.
Okay, ma'am, if you want to tell us who you are, you got to unmute.
Your Honor, that is not my client. So I'm going to ask for a bench warrant. Or I'm sorry, for a show cause.
I'll take your first suggestion.
Sorry.
Bench warrant will issue.
Thank you, Your Honor.
Council's request. Bond will be set. 10,000 cash surety. That warrant will issue immediately. Wow. Just forget which side you're on. Court calls the cases of the People versus Spencer Norton.
People, Your Honor.
Good morning, Judge Jeff Perlman on behalf of Spencer Norton.
Good morning, sir. And Mr. Jerkis, are you also?
Your Honor, I indicated with brother counsel, and he's substituting in. He had asked for permission to sign my name and get those forms to the court. I know that's being facilitated.
But we don't have them yet, right? We do? Okay, they're in. Okay. All right, great. Okay, he's in on all of them now.
Thank you.
Thank you. All right, your name, sir?
Spencer Norton.
Okay, what are we doing on these cases?
Yes, Judge. I've received discovery from Mr. Drukas and from the prosecutor's office, and we're asking to schedule these matters for exam.
So, and you believe all discovery is complete, sir?
Yes.
All right. Would the people have their witnesses available July 8th?
We'll do our best, Your Honor.
Judge, I do have an exam that day. is the court available? Oh, I'm sorry, would the court be available in the afternoon on the 8th?
Well, I'm sure it might be, but I'm not here. And we set them all at 9 a.m. in the morning. I can give you the following week if that's what you want.
The 22nd, Judge, if that works, because I'm going to be out of town the 15th.
Preliminary examination will be set July 22nd, 2025, 9 a.m. That's before Judge Barr. Correct. 9 a.m. before Judge Barr.
Thank you, Judge.
Thank you. Bond will continue in these matters.
Thank you. Have a good day.
Okay, you too. Court does call the case of the People versus Andrew Burke.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Burke, who is present via Zoom. Sir, can you please unmute and state your name for the court?
I'm sorry, Andrew Burke.
Thank you.
Thank you, Your Honor. I'm respectfully requesting an adjournment to receive and review the media discovery in this case. I have discussed this with both Mr. Cook and my client.
Probable cause conference July 10th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. Thank you, Mr. Burke. You're all set for today.
Thank you.
Court calls case People versus Timothy Folsom.
And then on behalf of the people, Your Honor.
Who they have?
Yes.
Asli Bashir on behalf of Timothy Folsom.
Your name, sir?
Timothy Folsom.
Thank you. What are we doing?
We're requesting the earliest available preliminary exam date,
Discovery is complete.
to our knowledge.
People have their witnesses available the 8th.
We'll do our best, Your Honor.
Preliminary examination in person, July 8th, 2025, 9 a.m. That is before Judge Fresh Hour.
Thank you, Your Honor.
Thank you. Bond will continue. Court calls case People versus Jamie Burke.
Your Honor, Alexis Plumai on behalf of Mr. Burke. Your Honor, I haven't been able to reach Mr. Burke. I did speak to his mom yesterday. She said she would tell him to call me, but I haven't got a call back, and obviously Mr. Burke is not here.
Mr. Burke went to 15th District Court. He had contact with the clerk's office. That was a while ago.
Your Honor, could we pass the matter?
Why are you helping her? What?
I would join the defense counsel's request for
I'll pass the matter.
Thank you.
Court does call the case of People versus Matthew Fonseca.
I'm not ready to put the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Fonseca. Mr. Fonseca, please state your name for the record.
Matthew Louis Fonseca.
Thank you.
Your Honor, regarding the PCC, we're asking for an adjournment. Mr. Cook and I are engaged in resolution discussions, and I would like to address bond if I may. Thank you, Mr. Allen.
July 10th, 2025, 9 a.m. Yes, as to bond, Ms. Perry.
Mr. Fonseca's bond on this case, as well as another case pending before Your Honor, is 510%. To me, that sounds like a credit type of bond. When Mr. Cook and I discussed it prior to the hearing, he
just makes up stuff.
It sounds right to me.
I
But he did have holds at the time of the arraignment, which are no longer holding them. So I wonder if that was the magistrate's intention. Regardless, I don't want to put words in the magistrate's mouth, but I would be asking for a personal bond for Mr. Fonseca. This is a nonviolent felony charge, Your Honor. He's been very communicative with me. He's eager to resolve all of his cases. He would be staying at the Delana Center if released. He had employment at Gandy Dancer prior to being incarcerated.
What's the other case, though?
The other case is a retail fraud before Your Honor. And then he has 2 cases out of 14A2 misdemeanors that have $1 each. So his,
excuse me?
Yeah, $1 each. So his total bond holding him is $102, but he's unable to post that.
Yeah. You believe that?
Do you believe it, Mr. Allen?
Sorry, didn't mean to put you on the spot. Is there a response from the people?
No objection from the people. I just know 2 out of county from Adrian. I see they are inactive holds for a large weekly auto and attempt to purchase a full RNO. I don't believe they're going to be picking him up on those.
Bond in this case is reduced to a $500 personal recognizance bond. In this matter, so I'll grant the motion for bond reduction. What is the other matter before me set?
The second.
The second. So if you get a stipulation to me, I'll sign off on that one.
Thank you, Your Honor.
All right. So that court does call the case People versus Bradley Chavez.
Thank you, Your Honor. Constable Basin on behalf of Mr. Bradley Chavez, who's present to my right. Bradley, can you state your full name for the record, please?
Bradley Chavez.
Thank you. You know, today's the date and time set for a probable cause conference. At this time, we're going to be requesting an adjournment. Our office has not received discovery as of yesterday in the evening.
July 10th, 2025, 9 a.m. bound.
Thank you, Your Honor.
Thank you. Court calls case People versus Douglas Hill.
Stephanie Cannon on behalf of Mr. Hill, who's appearing to my right. Mr. Hill, could you please state your name for the record?
Douglas Hill.
Your Honor, we are just simply asking this case be set for a preliminary exam.
You sure?
Yes.
No, I'm kidding.
Yes. Yes.
Never quite know what you're asking. Is discovery complete?
To my knowledge, it is, yes, Your Honor.
People have their witnesses available the 8th.
That's fine.
Preliminary examination in person will be set July 8th, 2025, 9 a.m. before Judge. Fresh hour. Bond continued. Court does call the case People versus Deshaun Clifton.
Stephanie Cannon on behalf of Mr. Clifton.
Your name?
Deshaun Clifton.
Your Honor, we are simply asking for a 2-week adjournment. He's gone through our AIM process. It's my understanding we will have the information, so I should be able to mitigate this down, or hopefully mitigate it down.
That objection, July 10th, 2025, 9 a.m. Bond continued. Thank you. Court calls case People versus Mark Hubbard.
And then on behalf of the people, Your Honor.
Mr. Judge. Portion of on behalf of Mr. Mark Hubbard, who is approaching the podium.
Your name, sir?
Mark Hubbard.
Thank you.
Thank you, Judge. I have spoken to Mr. Hubbard and to the people on this matter. We are requesting a 2-week adjournment. There are some videos that were turned over to our office. Mr. Hubbard would like to review those a little further and have me review them with his with one of the family members who helps him make some decisions.
July 10th, 2025, 9 a.m. bond continued.
Thank you, Judge.
Court calls case People versus Antoine Coleman.
Ready, Judge. Court shall please the first assistant public defender on behalf of Mr. Coleman, who is approaching the podium. Record, sir.
Antoine Coleman.
Thank you, Judge. Mr. Coleman has started the evaluation process with 14B Recovery Court. That is not yet completed. If we could have a brief adjournment, please.
Probable cause conference, July 17th, 2005.
Thank you, Judge.
Bond continued.
My birthday, July 6th. Thank you.
All right, thank you. Court calls the case People versus Stephen Johnston.
And Laura Yagus is public defender with, and on behalf of Mr. Johnson, who is standing to my right, could you state your name for the court?
Stephen Michael Johnson.
Your Honor, I do have a green sheet here. I am asking for another adjournment. I know it's been adjourned a few times, but I would ask for another adjournment for continued conversations with Mr. Johnson. We're attempting to set up a plan for him to get into treatment.
Got it. July 10th, 2025, 9 a.m. bond continued.
Thank you, Your Honor.
They're probably Court does call the case People versus Parker Davis.
Morning, our name is Lucas People.
Mr. Public Defender Jay Bellinger on behalf of Mr. Davis, who is approaching. Mr. Davis, can you please state your name for the record?
Parker Bradley Davis.
And Your Honor, we're just requesting a 3-week adjournment for purposes of mitigation. I believe I will have that completed next week, and I'll send that over to the prosecutor for review.
July 17th, 2025, 9 a.m. Bond.
Thank you.
Court calls case People versus Jeffrey Lewis.
Assistant Public Defender Jay Bellinger on behalf of Mr. Lewis, who approaches. Lewis, can you please state your name for the record?
Jeffrey Scott Lewis.
And Your Honor, I believe we have reached a resolution in this matter that would require a waiver. So my client's prepared to do that today, and I'll let Mr. Kennedy put that offer on the record.
The offer is to join the costing for all purposes. That's a max penalty of $1,000 fine, and count 3 of accused of the crime, imprisonment of 4 years or more, less than 10 years. Sentencing agreement and no probation conditions as set forth by probation.
That is my understanding of the agreement, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on the 3 counts.
Thank you, Your Honor. We acknowledge receipt of information. Waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
July 17th, 2025 at 1:30.
July 17th, 2025, 1:30, Judge Slay.
Thank you.
Bond continued.
Thank you.
Okay. Thank you.
Court calls case of People versus London Daughtery.
Ready, Judge. Court shall please the assistant London Daughtery. Sent to my right at the podium. Please state your name for the record, sir.
London Daughtery.
Thank you, Judge. Spoken to Mr. Daughtery and to Mr. Childress. My understanding is the people have made a request to see if there's any body cam or video footage from the car in this incident. They're going to confirm that, so I'm asking for a brief 2-week adjournment, Your Honor.
Probable cause conference will be July 10th, 2025, 9 a.m. Bond will continue.
Thank you very much, Judge.
Nobody at the door. Court does call the case, People versus Jaleesa McDowell.
Alexander, on behalf of the people, Your Honor. Asif Bashir on behalf of Jaleesa McDowell.
Oh, Jaleesa McDowell.
In Your Honor, we would like to address bond in this matter and request the briefest possible adjournment.
Okay. Go ahead. I'll let you address mine before I give you the date, I guess.
Thank you. Before I kind of address the substantive bond in this matter, I do want to address kind of clerical error in another case. The court may see that for case, there's a case out of 14A2, 25203, or, oh, sorry. Okay, actually, you know what? I'll save that for the end if it comes up. Just because it looks like she's being held on another matter for a higher bond than she actually has, at least in the system that I.
Out of my court?
Oh, sorry, 1482.
So what would you want me to do with that?
Well, in case that was part of your consideration for.
Oh, I see.
Apologies.
You don't want me to change it.
No, I do. Oh, so as far as this matters, yeah.
You can go to Judge Barr, but go ahead.
So as far as this court is concerned, Ms. McDowell is being held on a $50,000 bond. This is the result of an emergency bond motion and the court's order in response to that motion, that hearing on the June 16th. Circumstances have changed since that hearing. My understanding is at that time, the complaining witness was residing very close to where Ms. McDowell resides.
Have the circumstances changed to the extent that the allegation of a knife to the body or hand of a 15-year-old has changed?
Yes. Well, the charged, alleged, conduct in the police report, as far as that report, which, we have not had any substantive, hearings on the merits on that matter, but the report hasn't changed to my knowledge. But we have, stood mute on that matter.
Yeah, screenshots.
Yeah. And we do, we are gathering discovery on the matter. And I would say in terms of the kind of concerns related to bond about Ms. McDowell being close to the complaining witness, I do believe that the complaining witness, I understand, is residing in Detroit with her grandmother. She no longer resides next door to Ms. McDowell. Ms. McDowell also she's been in custody for 15 days on this matter. She is willing to go on GPS tether. She has, support in the court. She has a coworker and friend who is here today. Her sister was planning to be here today, but was not able to. I do think that additionally, the hardship of her being in custody is something I request the court take into account. She's concerned about the security of her residence. She's been informed that there has been potential vandalism and potential people breaking into her home while she's been out. No one else is officially residing there. Ms. McDowell has there's no allegations of Ms. McDowell trying to contact the complaining witness. There's no allegations that she's been making jail calls. She has no intention of contacting the complaining witness in this case, and she understands the seriousness of that. And so I do believe that the being held in custody on a $50,000 bond is excessive in this matter. We can address. Yeah, okay.
You're saying the bond I set was excessive?
Well, at present, given the current circumstances, which have changed, the information you had before you then is not the same as the information as it is now. Of course, I would not question the court's judgment. But specifically, because of the potential hardship to her and the concerns about her home, the concerns about the fact that she is no longer anywhere near, she won't be anywhere near the complaining witness. And, she has already been in custody for 15 days. The final matter is, she has, she works as a supervisor at her workplace. She's been there for 5.5 years. She is very concerned about, her job. And so I would request, that she be able to be released to work. I understand that one of the release conditions includes a GPS tether. She's happy to go on a GPS tether and follow any conditions this court thinks are appropriate for her to be released. But if the court would consider, her.
Where are the other 2 children?
My kids were left at home attended for 2.5 weeks, sir. And I literally moved my kids to Detroit to my mom. They are safe now, and I did sign my rights over, sir. But my children were left home attended for 2.5 weeks. I sent cash up money to them.
This is Ms. McDowell. I don't think we want to address anything with the children right now, other than the fact that they're residing with their grandmother.
I got the move. I just want you to know that, sir.
And Ms. McDowell, all 3 children are living with the grandmother.
And I've been working from my jail cell for 3.5 hours a week because I had to still provide for my children because I knew that they were home left attended. I have that on recording on the jail cell as well. With the CPS lady, her name is Tiffany Avery, sir.
And to be clear, this is not a conversation involving the children. It was just.
And I've never been accused of anything violent. The other accused, the malicious property destruction, I have a $10 bond, sir, and that is taken care of. And it was just you prosecuted her rapist, and that was the
Ms. McDowell, I think if you can just hold off on saying, I think we'll address anything.
I just wanted to speak up for myself, sir, because I'm not a criminal, sir, and I really, really do need to go to work, sir. I've exhausted my funds, and I've been taking care of my children for 2.5 weeks. I didn't make contact, but I do know that they were home by themselves. And it just was discovered. And the CPS worker is going to be providing those information as well. I'm sorry, sir.
That is all, Your Honor.
Your Honor, if the court's familiar with this case, I'm not going to re-exhaust the motion that we filed. The only thing that I see that's changed since last hearing is that the children have been placed with that grandmother in Detroit. The facts of this case still stand that she is stabbing her daughter with a butter knife so severely that her daughter needed stitches in her hand. I mean, I have severe concerns, and not only that, she threatened to kill her daughter, and her daughter was so afraid to contact police, she had to text a friend to call police because she was so afraid of her. I mean, I have great concerns, even if she is released, for her children's safety. And this is a very significant case, and I believe in our bond form, our original request was $100,000, so $50,000 as set by the court is appropriate in this case and should remain as set.
Your Honor, if I may address that, there is no history of violent conduct between Ms. McDowell and the complaining witness in this case. The basis of the statements that were just made by the people are entirely the police report in this case.
And
again,
her stitches.
Well, the basis of the allegation that Ms. McDowell is the cause of the injury is based on the police report. That has not been addressed on the merits. And again, there's no history of legal issues or reports of violence between Ms. McDowell and her children. I would say, I don't believe, I would like the court to consider the gravity of holding her in custody on the basis of just the police report at this stage of the case with no allegations that she has violated her.
Telling me it's wrong that the child was at the hospital getting stitches, counsel, and that's what I should consider?
I want the court to consider the fact that that Ms. McDowell has stood mute. The court has entered an act.
I understand all of that, but you're asking me to consider her hardship and saying that there are certain things that may be objective in that police report that I shouldn't consider that.
I would like the court to consider the fact that Ms. McDowell is no longer going to be anywhere near that child. So if there is a concern about the possibility that that injury may have been caused by Ms. McDowell, which we deny, that would be addressed by that fact. In addition to the fact that there would be a GPS tether as part of her bond conditions.
And Your Honor, I did also make the record clear. She does have a previous conviction for domestic violence from 2018. She also has a previous conviction for larceny from 2020, and she also has the pending case of the MDOT with another domestic relationship So I mean, I do have concerns. She does have an assault history, and given this case, I'm concerned that it's escalating from what her previous history is.
Your Honor, none of these cases involve Ms. McDowell's children.
Yeah, but you said she didn't have a violent history. She's got a DV conviction. Motion for bond reduction is denied. Bond will continue.
And Your Honor, did we set a date?
I don't know, July 3rd, 1 week out. 9 a.m. Court calls the case People versus Tommy Lee Ellis.
Hello, basically on behalf of Mr. Ellis, Your Honor. He's present to my right.
Okay.
Thomas Ellis.
Thank you.
I ain't been called Tommy in many years.
Pardon?
I ain't been called Tommy in many years.
All right, what are we doing?
Your Honor, we're going to be requesting an adjournment to the July 17th date. My client has been screened with a 14B recovery court. We're just waiting to see if he's going to be accepted into that or not.
You're gonna take him to the 17th to do that?
Well, next week, or I'm sorry, that's the next available date.
Birthday.
No, I haven't.
He has some medical issues that he needs to take
Medical.
care of.
Gotcha.
I think that.
Probable cause conference, July 17th, 2025, 9 a.m. Bond continues. All right, thank you.
Thank you, Your Honor.
Court calls case People versus Alexander McMullen.
Assistant Public Defender Chelsea Vergils with and on behalf of Alexander McMullen, please state your name.
Alexander McMullen.
Thank you.
Your Honor, today we are asking to set a set a preliminary exam and asking to address bond.
All discovery is complete.
Yes, I believe so, Your Honor.
People have their witnesses available the 8th. Preliminary examination in person, July 8th, 2025, 9 a.m. before Judge Freshour. As to bond.
Your Honor, we're asking you to consider release on a personal bond with a home confinement tether. Mr. McMullen is a local man. He has family in Washtenaw. He proudly graduated from Milan High School and had been, prior to his incarceration, working part-time at a hotel in Ann Arbor. He does have a parole hold, but he has spoken with his parole officer and does not believe he would be violated for this case, so he hopes to just continue on with his parole.
Do you have confirmation of that?
I don't, Your Honor. No, I haven't spoken with the officer. That concludes my request for a personal bond.
Any response from the people?
I mean, Your Honor, the defense tried to appeal the position in front of the police. He was cited by the police officers for breaking in cars. They attempted to stop him, jumped in the car, about to chase crash before that led that vehicle was apprehended shortly thereafter by police. It taken me a while.
But needless to say, he was on parole at the time of this.
He was just given a year in jail for resistance.
Motion for bond reductions tonight, bond will.
Thank you, Your Honor.
Court does call the case People versus Durantu Francis.
Ashley for the people. Stephanie Capital Francis was appearing by Zoom.
Your name?
Durantu Francis.
Thank you. All right.
And Your Honor, we are going to waive our right to preliminary exam in this case.
All right. Is that a correct statement, Ms. Francis?
Yes, Your Honor.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count. Now, how did they do this? Oh, I see what they did. All right. On count 1 with 2 and 3 following.
Thank you, Your Honor. We would waive formal reading of the information, and we just ask for our pretrial date. Oh, we stand mute as to the charges. Sorry.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all charges. Pretrial will be set for
August 20th, 2025 at 1:30 with Judge Thomas.
August 20th, 2025, 1:30, Judge Conlon.
Thank you so much, Your Honor.
Thank you. Bond continued.
Thank you, Your Honor.
Thank you. Good luck to you, man. Court calls cases of the people versus Jacqueline Murray.
Good morning, Assistant Public Defender Lauren Penny on behalf of Miss Murray, who is approaching. Miss Murray, please state your name for the record. Jacqueline Murray. Your Honor, we are requesting adjournments on the 3 cases. We're working out a plea that would hopefully encompass all cases and is dependent on Miss Murray completing the in-jail Dawn Farm program, which she's already enrolled in.
So, just so that I'm clear, the plea is contingent upon her completing that.
Yes.
How much more time does she have to go in that?
I have no idea. Every time I have class, I'm here, so in court, so.
All right. Well, I'm trying to anticipate a date that she might complete.
Well, I think it's an 80-day program. She has started attending, which is good because there is a wait list. She is serving a 93-day sentence out of another court, right?
I think this one.
So.
Well, why don't I do this? Also, so that she's not missing classes. Why don't I adjourn this then to August 7th? Okay.
And if the circumstances change, we'll get in
Right,
touch.
then you can get to the court and we can move her date up since she's in custody, but I think she's missing class when she's here. I think that's what she's telling me. I
Yeah.
don't want her to miss class. That's gonna be it. All right?
Thank you, Your Honor.
Thank you.
Thank you. Court does call the case, People versus Jalen Kendrick.
Alexander on behalf of the people, Your Honor.
Assistant Public Defender Jay Bellinger on behalf of Mr. Kendrick, who appears via Zoom. Mr. Kendrick, can you please state your name for the record?
It's Alan Kendrick.
Thank
Your Honor, maybe briefly approach.
Yes, you may.
Thank you.
On this matter, record to reflect, we've had a brief bench conference. The court is going to pass this matter to the 12:30 block. Sir, you need to appear in person in the 12:30 block. You understand that, sir?
12:30. Where's that? Oh, you saying like time wise?
Yes. And you need to come down to the court.
It's going to be the 14A1 District Court before Judge Simpson.
Okay, I'm gonna have to call my job because they wanted me to come do a drill test at Concentra. At 12?
Well, I would say, Mr. Kendrick, that court takes priority at this point.
Okay,
So I would get down here.
okay. I'll be there.
Thank you.
Thank you.
Yeah.
Court calls case People versus Benjamin Peterson.
Alexander, on behalf of people, Your Honor. Student attorney Kara Rose Warren under the supervision of First Assistant PD Michael Gaddy. On behalf of Mr. Peterson, can you state your name for the court?
Benjamin Donald Peterson.
Thank you.
Your Honor, we're going to be requesting that the court set a date for Mr. Peterson's exam, and we'd also like to address the issue of bond when the court's ready.
You have all discovered.
Yes, to my knowledge.
People have their witnesses available the 8th.
We'll do our best, Your Honor.
Preliminary examination in person, July 8th, 2025. 9 a.m. before Judge.
Judge Freshour.
Fresh hour.
Thank you, Your Honor. May I address bond?
You may.
Your Honor, our client has informed us that he has no prior convictions and he was extradited from the state of Missouri where he resides. He is willing to stay on a GPS tether and remain in the state of Michigan, or alternatively, he can leave the
So
state.
we had to extradite him?
Yes.
Hey, go ahead.
Or alternatively, he can leave the state of Michigan and not return, and he's willing to do all of his court hearings over Zoom. He does have employment.
Why would we do that if we extradited him? I mean, what? Did he waive extradition? But we had to get him here, right?
Yes, sir.
So if we had to bring him from another state, and I'll wait for your answer, why would I let him leave this state? And why would I let him basically be out of custody at this point?
Well, Your Honor, he's willing to stay in state on a GPS tether.
But he wasn't willing to come here to address these issues.
Yeah, he waived.
Go ahead, I'll let you complete your argument for the record, but.
Okay, thank you, Your Honor. I appreciate it. We were just requesting a personal bond, or if the court was not inclined to grant this, a lower bond with a 10% option.
Okay, I don't need a response, but thank you for standing. Most for bond reductions denied. I think it's rather evident on the record as to why the court is denying that. So his bond is denied. The exam is set for the 8th. Thank you.
Thank you, Your Honor.
Clerk calls the case People versus James Taylor.
Our attorney requesting conviction of practice pursuant to Michigan Court Rule 8.120 under the supervision of APA Andrew Taylor's government.
Duration of practice is granted.
Edward Drukas for James Taylor, Your Honor.
All right.
And I don't see him coming up to the podium. I had been in.
Because he's not.
He did get released out of Ingham County. I had been in communication with his attorney up there. I did get a new updated contact information, and he may not be aware of this date. I've not been able to speak.
Really?
Mr. Taylor. His last date, he was in Ingham County, and I don't know if, but got released shortly thereafter.
He has a bond violation pending, which may be a result of him being in custody, but he hasn't come down to do anything. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000 cash surety. That bond will issue immediately. Yes. Court does call the case of the people versus Barrage Scott.
For the judge. Court shall feast on behalf of Mr. Barrage Scott, who is the person on the podium. Mr. Scott, please state your name for the record.
Well, I don't take Scott, sir.
How you doing?
All right, just glad to see my family in here, that's all.
Thank you, Judge.
Been here every time for you.
All right. Thank you, Judge. I believe this is a competency review. My understanding is that we do have a report. Scott is competent, Your Honor.
Yes.
We stipulate that, Your Honor.
And the people?
But also stipulate that the defendant is competent.
All right. The court, having reviewed the report, would find that the defendant is competent to stand trial. The defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is found competent.
Judge, I'll be asking this matter be set for a PCC, and Mr. Scott would like me to address bond as possible.
All right. Probable cause conference will be set for July 10th, 2025, 9 a.m.
Thank you, Judge. I've had a chance to talk to Mr. Scott about the situation, and I've relayed to him how serious of a charge he is facing. Mr. Scott is still asking that I seek a personal bond from him on this case, Your Honor. Although the court does see that Mr. Scott is competent, Mr. Scott does indicate that he suffers from a variety of mental health conditions. He indicates that he would love to get this situation resolved. He would love to see his prosecutor's office potentially offer him a mental health court resolution. He says that he's not going to run from this situation. He has family support. He indicates that his mental state is in a much better place now than it was at the time of this alleged event. He indicates that he has a grandmother who is involved in his life and who will help make sure he attends any and all court dates. He indicates he will go to any outpatient or inpatient treatment that the court does require. He also has no objection to being on a tether. He indicates he's willing to just address everything that's going on in his life, Your Honor, that he will not be a problem for Your Honor should the court release him. He's asking that Your Honor consider a reduction in bond or a potential personal bond. But again, I have relayed to him how serious of a charge he's facing. But I believe that's what you want me to argue. Anything else? Mr. Scott says that he's on his medication now, and he's obviously much better when he's on his medication than he is when he's off his medication, and he will stay on his medication should the court allow him an opportunity to be released. And that the nurses in the jail have upped his medication in certain areas and have him on a shot and a pill form.
Yes.
And so his mental mind frame is in a better place, and he will do anything and everything the court asks, but he's asking for potential release.
I would ask that bond remain as currently set. I appreciate Mr. Feaster's advocacy on behalf of his client. I'm struck by the, I think it was in the competency report. Mr. Scott affected a volitionally uncooperative response out during the evaluation process and attempted to feign legal knowledge, memory deficits, and symptoms of severe. Candidly, if you're uncooperative in the underlying competency evaluation, given his criminal history and the facts of this case, I believe that he is a danger to the community and has
Nothing further, Judge.
All right. I am going to deny the defendant's request for a bond reduction in this case. I think the bond is set appropriately. I would further indicate that Mr. Scott's been appearing before this court for quite some time on various matters. And typically I can let Mr. Scott out of custody, he may come back in, but usually for minor things. Mr. Scott was in custody. I took a chance, released him. He did not make it a week before this came up. Mr. Scott was arrested. So I'm not gonna take that chance again, especially since it's
You understand what he's saying to
a
you?
violent case.
Hold on, do you understand what he said to you?
So
He said that he let you out. This happened a
I
week
understand. I
later.
know, but he keeps saying the same thing.
Okay.
Saying the same thing that he said.
Okay.
He's not.
I believe Mr. Scott wants to address you directly, Your Honor, if you
go ahead, Mr. Scott.
Listen, Mr. Simpson, I know you kind of keep, going back in the past, right? But this is my life. You know what I'm saying? My grandma's here, my family's here. People are making me look bad. Even a competency hearing, they're making me look bad. I answered everything what I was supposed to answer the right way, and the prosecutor saying I was I wasn't cooperating the correct way, and I was. It seems like I had to take 2 competency tests. And the first one, he just said what he wanted to say. I'm asking if you release me today, because I gotta go see Slay today. They said if I do get released, they're gonna follow the same recommendations you will follow if they put me on tether, if they put me in. You never put me in no classes. You never ever put me in no classes or try to do anything like that. I want my days to be filled. If I'm on tether and I have a curfew, I want my days to be filled. I be with my auntie, stuff like that. I go to classes. I go to Don Farms. I need this. I need help. I have a drug problem. I never addressed it like this, but after my sister died last year, she died. She had passed away at 23. I went crazy. I didn't understand half of the things. She had heart failure. It's my grandma. She's 70 years old, something like that. What it happen if you keep me in here and then she just something happens? No, listen.
Mr. Scott, no, you listen. No, you listen.
But
I'm done. I let you out. I gave you a chance. I've given you numerous chances. Saying that anybody's trying to make you look bad, I don't have to go to the past. I let you out. You don't make it 8 days. And now I have you involved in a crime that involves pointing a gun at another person. I'm done.
What do you mean?
Listen,
can you just
motion for bond reduction denied, bond will continue.
Thank you, Judge.
But you ain't let me speak, though. You ain't even let me speak.
Thank you, Judge.
Court calls the case, People versus John Terry.
Oh, Jennifer does it for the people? Your Honor, Alexis, whom I am appearing with, and on behalf of Mr. Terry. Mr. Terry, could you state your full name?
John Martin Terry.
Your Honor, I do have a green sheet here. I am requesting just a 1-week adjournment. Mr. Terry did provide, or his mother provided the documentation that the people had requested in consideration for an offer. So we should be able to get the case resolved next week. And additionally, Mr. Terry would like me to address bond. I will be brief.
You'll be brief?
I will.
That'd be a change. I'll adjourn this to July 3rd, 2025, 9 a.m. Go ahead, counsel.
Your Honor, so today, Mr. Terry's mother provided proof that Mr. Terry has been participating since February of this year in medically assisted treatment through Packard Health for substance use disorder, as well as psychiatric treatment through community mental health. He would like to be released so that he can continue with that treatment. He does have a full-time job that he could go back to, and he now has reliable transportation to and from court in the form of his mother. I believe originally the warrant had been issued because he was unable to make it to his last probable cause conference date. There was also a community corrections bond violation report. He does acknowledge that he had a slip up there. It's a problem that he's working on with Packard Health, and he'd like to continue to do so out of custody. So he's asking you to consider a personal recognizance bond, Your Honor.
I'm going to deny the request for bond reduction. I don't need a response. There has been a previous violation in the past, and the defendant doesn't appear. And so I'm going to deny that request. His bond will continue. I'll set this for July 3rd, 1 week out, 2025, 9 a.m. Court does call the case, People versus Thomas Basher.
Washtenaw for the people.
Ashley Bashir for Thomas Basher. Or Bashir, Thomas Bashir. Who is approaching. And Bashir, you can say.
Thomas Bishop.
Okay. All right. What are we doing?
Your Honor, I understand we reached a resolution with the people on this matter, but in order to follow the court's procedures, we're requesting the briefest possible adjournment. If it would be possible to have a 1 week adjournment on this matter.
July 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue.
Oh, sorry. And
Go
also,
ahead.
yeah, sorry.
Address my bond.
Yeah, thank you, Your Honor. Mr. Basher has been in, or Mr. Bashir has been in custody for 38 days. I understand the basis of Mr. Bashir's alleged current bond status. His bond is denied, is based on an alleged violation that results from a police report dated April 1st. As far as I know, right now it's June 26th. As far as I know, no charges have been authorized on the basis of that report, and it hasn't resulted in a new case. I would like the court to take that into consideration. Yeah, and Mr. Bashir has also demonstrated that he presently is not a flight risk. If the court may recall, on June 17th, he appeared from a hospital bed for his hearing. He had a serious injury, but he is very serious about making it to court. The basis of this case is a non-violent felony, and I don't believe he's a danger to the community.
Counsel, this is the third time that I've had to hear this same bond argument.
Including that, well, I guess he appeared from the hospital bed at the last hearing, so that's a new thing, right? And I would note, I think the time between now and the fact that nothing has resulted even now from that report, I think is worth taking into consideration for his bond.
Response?
Your Honor, he did have a prior failure to appear in this case in February of this year. I would note it appears there are at least 2 new warrant requests under review from my office. The fact that their charges have not been issued does not mean charges won't be issued, but there are cases that are under review right now from this year, from 2025. And it appears to be in the time frame for which he did not appear before the court. I would disagree with the characterization that he's not a flight risk based on his history of failing to appear, and ask you to continue the bond for 1 week.
Set this out July 3rd, 2025, 9 a.m. Motion for bond reduction denied. Bond will. Court does call the case. People versus Gustavo Reyes.
Washtenaw for the people.
Assistant Public Defender Natalie Pay on behalf of Mr. Reyes, Your Honor, who is not present. The information I received from his immigration attorney is that he's been detained. I don't have documentation of that other than what I received from that other attorney. That is my explanation for his failure to appear. I do know there was the bond violation, and I know it probably doesn't matter at this point because he's not here with us today. I do know he was previously showing up to testing and in compliance before, I believe. His stopping of testing, I believe, lines up with when he was detained.
Bench warrant 10,000, cash surety. Warrant will issue immediately.
Thank you, Your Honor.
I'll recall. You there? Court recalls case People versus Christopher Atkins.
Morning, Judge. Brian Bowling on behalf of Mr. Atkins.
No longer there. Released to treatment yesterday.
That is accurate. That's my understanding, Judge. He is at a Salvation Army facility in the city of Detroit. He is actually scheduled to be sentenced on that Livingston County matter on July 10th at 8:30 a.m. That's the set time. It's my understanding from the point of contact I have for Mr. Atkins is that the Salvation Army program is at least a 6-month program and basically is part of what they expect the sentence to be on the Livingston County matter in their, what they call their IT court there. So ultimately, I'll leave it to the court. If you want to do the 10th, obviously I have no problem with that.
Well, except that I'd be doing it at 9, and then he's got that appearance at 8:30.
Right, yeah, no, I get.
So
if we,
why don't we do this, and this way, I think you can also kind of catch up on it. I'll adjourn this to July 22nd. That's a Tuesday, so but I'll adjourn it to July 22nd, 2025, 9 a.m. So maybe we can find a way to get him to appear and see exactly what he's doing.
Perfect, thanks, Chris. I do have a green for him if you want it for the file. Thank you, Ron.
Thank you. Court does call the case, People versus Jamie Burke. Burke?
I apologize, Your Honor. Alexis Bloom, I'm appearing on behalf of Mr. Burke. Your Honor, I'm not sure why he hasn't made it over here. And I haven't had contact with him. The only number that I have is for his mother.
Bench warrant will issue for defendant to appear. Bond $10,000. The warrant will issue.
Understood. Thank you.
Thank you.
Swear in the Spanish interpreter.
You may.
Good morning, Liliana. You're in front of the Honorable J. Cedric Simpson out of the 14A District Court, Washtenaw County, State of Michigan. We need your assistance with one matter this morning. Our number is 1423.
Is he here?
He's in custody at this time.
Okay.
Yes, thank you. I'm ready for your instructions.
Can you please raise your right hand to be sworn? Do you solemnly swear or affirm that you'll interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Spanish and from Spanish into English in a manner not before the court, so help you God?